Morning, ladies and gentlemen. I'm pleased you're all able to join us this morning for this presentation. The drivers behind this seminar are the significant issues which everybody's experiencing in the market at the moment in relation to price increases in materials, extended lead-in periods for delivery, labour shortages, and just thinking ahead, the possibility of the problem being exacerbated by the drive to net zero carbon. Speakers this morning are David Arnott and Chris Duff, Juliet Haldane and Jane McMonigal in that order. And what they're proposing to do is to look at the existing industry standard forms, how they deal with these issues under the relevant provisions, and how parties may be able to work collaboratively going forward to address and mitigate the issues that are being experienced through use of new clauses and amendments to these. If time allows, at the end, we should be able to take questions, but there's quite a lot to get through, so we'll just see how that goes. And with that, I'll pass over to David.
Good morning. Thanks, Al. If you are wanting to do questions, there's a Q&A function at the bottom, so use that, and your questions won't be seen by everybody, but they'll come through to us. So why are we here today? The reason, as Al has mentioned, sorry, Ashton, could you move that slide on? Thank you. The reason, as Al has mentioned, is that there have been significant price increases and extended lead-in times for materials in recent months, and those have been resulting in cost rises and significant delays to projects. We've seen that particular problem arise with steel, plastic, cement, timber, copper, and also labour, and undoubtedly a number of other materials and products. What has caused this? Well, unfortunately, we have a perfect storm at present. COVID-19, Brexit, the housing boom, market recovery, supplier opportunism, and as Al mentioned, also that the emissions issue and the reduction in carbon emissions that's now being imposed. As we will discuss, this combination of different reasons makes it more difficult to analyse the parties' contractual responsibilities. So how do the standard forms deal with such matters? Well, what I want to do this morning is review the position under the NEC construction contract or construction and engineering contract and look at how it deals with the position. And then Chris will then deal with the position under SBCC. So under NEC, there are a number of clauses that may potentially be relevant depending on the main option that has been selected by the parties and the terms of NEZ clauses. Dealing with these clauses in turn, firstly, clause 16, early warning. The contractor or the project manager should give an early warning as soon as they become aware of any matter which could delay completion or delay meeting a key date. They can also give an early warning of other matters which could increase the total of the prices. Therefore, issues with material availability and lead-in times or price increases can be early warned by either the contractor or the project manager. A risk reduction meeting can be called by either party, and those who attend cooperate at that meeting to agree actions to try and avoid or reduce the identified risk. If the outcome or decisions taken at that meeting require a change to the works information, for example, the use of a different product or material, then the project manager gives an instruction to that effect. An instruction changing the works information can amount to a compensation event under clause 60.1.1, which I'll come back to. I can foresee project managers being reluctant to instruct a change if it will result in a compensation event. However, simply because a change amounts to a compensation event does not necessarily mean that the employer will have to pay additional costs. In the particular circumstances that we are discussing, the defined cost of executing the works and the time taken to execute the works is likely to reduce rather than increase as a result of any change, because it's been driven by the fact that costs and time were going to go up in the first place due to the problem in obtaining materials. So that's the whole reason for making the change. Project managers should also be mindful of their obligation to cooperate in terms of clause 16.3 and the obligation to act in the spirit of mutual trust and cooperation under clause 10. The next potentially relevant clause is clause 18, which deals with impossibility. If the works information requires the contractor to do anything which is impossible, then the contractor can notify the project manager. It may be possible to argue that this means commercially impossible rather than absolutely impossible. So, for example, if the works information requires the contractor to use a particular product and the unavailability of that product makes it impossible for the contractor to meet the completion date or a key date, then it might be possible to argue that that amounts to commercial impossibility and then comes within the terms of clause 18. If the project manager agrees, then he gives an instruction to change the works information. And again, such a change can amount to a compensation event in terms of clause 61.1. As with clause 16, I can again see project managers being reluctant to instruct changes if it will result in a compensation event. However, the comments I made in relation to defined cost not necessarily increasing and the obligations on the project manager are equally applicable here. Next up is clause 19, which deals with prevention. If an event occurs which stops the contractor completing the works by the date shown on the accepted programme, and which firstly, neither party could prevent, and secondly, it would have been unreasonable for the contractor to have allowed for it when the contract was entered into, then the project manager should give the contractor an instruction as to how to deal with the event. The event causing the delay can itself amount to a compensation event in terms of clause 60.119. So the event that's causing the prevention is a compensation event under that clause. But the project manager's instruction to remove the problem can also amount to a separate compensation event under clause 60.11, depending on what that instruction is. The critical issues under these clauses are firstly that the event has to impact on the contractor's ability to complete by the date shown on the accepted programme. Therefore, it won't apply if there's float, meaning that the completion date can still be met, notwithstanding the prevention. And it won't apply if the completion date has already passed, or other events mean that the completion date won't be met in any event. The event itself must impact on the completion date. Secondly, it cannot be an event that the contractor should reasonably have anticipated and allowed for. Therefore, this clause will be of no assistance for contracts which are being entered into now, nor for contracts that were entered into recent months when materials issues were already known about and should have been allowed for. Clause 21 is also potentially of relevance, and this clause covers contractor's design. If the contractor is carrying out any design, they may consider amending that design to omit any product or material that is causing difficulty and substitute an alternative, provided the alternative complies with the works information. The project manager requires to accept the amended design, but should not refuse acceptance if the works information and applicable law are met. The last core clause I want to look at is clause 60, which deals with compensation events. There are really two compensation events that might have some relevance. Firstly, clause 60.11, which deals with changes to the works information. Now, this clause contains the compensation event that potentially allows recovery of time and money for some of the clauses that I've already dealt with. So for example, if the project manager changes the works information in terms of clauses 16, 18 or 19 that we've already looked at, or otherwise changes the works information, then this can be a compensation event in terms of 60.11. If, however, a change by the project manager relates to the contractor's design and has been made at the contractor's request, however, so for example, a change to the design requested by the contractor under clause 21, then the project manager may rely on the second bullet point to 60.11 to refuse the compensation event. So the change will still happen if the contractor's requested it, but it won't be a compensation event. Secondly, the other relevant compensation event is under clause 60.119. This provides a compensation event which reflects the wording of clause 19 dealing with prevention that I've already mentioned. The wording is the same as clause 19, and as with clause 19, the critical issues are firstly that the event has impacted on the contractor's ability to complete by the date shown on the second programme, on the accepted programme, and secondly, cannot be an event that the contractor should reasonably have anticipated and allowed for. Therefore, it's probably only going to assist with contracts entered into many months ago and certainly not new contracts again. So having dealt with the core clauses, I also want to turn to a couple of the secondary option clauses which might be relevant. And firstly, option X1. Now, these are the options that the parties must select when entering into the contract if they want them to apply. So if X1 has been selected, it may provide for some increase in the amount payable to contractors for cost increases arising as a result of inflation. Under options A and B, the main options A and B, the contractor bears the risk of cost increases in the absence of option X1 having been selected by the parties. So any cost increase falls at his door. Under options C and D, any cost increases will be paid to the contractor through the price for work done to date, but then possibly recouped by the employer to some degree through the contractor's share mechanism. So if as a result of materials issues, the target price is exceeded, then the contractor may have to pay a proportion or possibly all of that excess back to the employer. So in relation to material increases, the employer may have to fund that increased cost throughout the project, but recoup some of it on completion. Under options E and F, the employer bears the risk of cost increases as these are cost reimbursable contracts. The other secondary option that I want to have a look at is X2, which might also be relevant in some circumstances. If the product or material difficulty can be identified as being the result of a change in law, then this will be treated as a compensation event under X2, assuming again that option has been selected by the parties when they entered into the contract. There's a couple of points to be aware of. Firstly, the change in law must be a change in law of the country where the site is located, and the change in law must occur after the contract date. Of course, proving that there is a change in law has caused the proving that a change in law has caused a supply difficulty or a price increase may be far from straightforward. One example where this might apply relates to the UK emissions trading scheme, for example. This was introduced by legislation following Brexit. Companies who are regulated by the scheme have allowances in respect of the amount of greenhouse gases that they can emit into the atmosphere each trading year. These allowances are more limited than they were under the EU scheme. Accordingly, some companies might have to increase the cost of materials to offset any costs they incur in buying additional allowances. And if that link could be shown to be the result of a price increase, then that's one example where option X2 might result in a compensation event. The last issue I want to consider is the assessment of compensation events under clause 63. Contractors may attempt to argue that earlier compensation events have pushed them into a position whereby product or material availability is an issue, but would not have been an issue but for earlier compensation events. If those earlier compensation events have not been quoted and agreed and implemented, then contractors may try to review the quotations for those earlier compensation events and include an allowance for material unavailability and price increases. Similarly, when pricing new compensation events, then contractors may seek to build an allowance or a risk element to cover product and material shortages or price increases. So in conclusion, there are quite a number of potentially relevant clauses under NEC 3 in relation to these issues. Obviously, one needs to check whether any changes have been made to the standard form by way of Z clauses, as is regularly the case with NEC. In relation to NEC 4, the potentially relevant clauses are identical to NEC 3, although some of the clause numbers have changed. So clause 15, early warning, or sorry, clause 16, which was previously early warning, has changed to clause 15, and clause 18, which was impossibility, has now changed to clause 17. And with that, I'll pass over to Chris. Thank you.
Thanks, David, and morning, everybody. I'm going to cover the position under the SBCC form of contracts. Particular clause numbering we've used in the slides is taken from the Design and Build Form for Scotland 2016 edition. And it's fair to say it's probably slightly slimmer pickings than the position that David has just taken us through in connection with NEC. First point I want to flag is just in connection with what the standard form provides for the way of substitution of materials, and that's under clause 2-1. Because obviously if there is a very long lead-in time or just impossibility of obtaining a particular material or a particular sort of material, then you may have to substitute. And that right is there, but it is subject to the employer's consent where that particular type of good or material has been described in the employer requirements, the contractor proposals, or other contractor design documents. So just flagging at the outset that on occasion, the simplest solution might be to try and swap out with agreement of your employer what you're finding difficult to source. In connection with specific reliefs, which might operate as between the parties, most will be familiar with the time and money regime, which operates under SBCC. So clause 226 is the relevant events, and thereunder the contractor can obtain, upon a relevant event, an appropriate extension of time. And there's a couple which could be engaged if there is a genuine issue sourcing material or genuine issue with a lead-in time, etc. So one of those would be 226(1), which is looking at effectively instructed changes. So if an instructed change introduces particular goods and materials which are difficult to source, then any delay occasioned thereby would ordinarily be recoverable under that relevant event. Similarly, under 226(12), if there is, after the base date, the exercise of a statutory power, which then affects the ability to obtain particular goods and materials or the supply of them, then that could also be a relevant event. But obviously it is very important to have the base date clearly identified, and it will be the contractor's risk for any legislative changes up to the base date. Next slide, please. 226(14) is the final of the relevant events flagged in the slides, and that's force majeure. That's had a good airing in the last year and a half or so, just in connection with COVID. That too may operate where there has been an unforeseen risk here. But do bear in mind that with everything that's gone on in the last year and a half, live projects may respond less positively in connection with force majeure, because there may be a debate over the extent to which issues at the moment are genuinely unforeseeable or not. Much like David had flagged in connection with NEC, it's certainly worth reviewing on both sides of the ledger, both contractors and employers, whether earlier events which the contract does operate to grant relief have pushed that project into a period where these material and labour issues are becoming a live issue for the project, because in that situation it should be possible to extend and grant relief because of that. But naturally, if that's going to happen, both sides would need to apply their mind to the programming analysis, and employers would need to be satisfied that the contractor can verify that it was earlier employer culpable events which have pushed the programme into this period, and that the claim more generally stacks up. So be aware of that. Next slide, please. One other area which the form do envisage in connection with material is the off-site early up or early ordering up of materials, and there's particular agreements which you can put in place to regulate that. I'm not going to say too much about that because that's something which my colleagues speaking after me will touch upon, but just be aware again that right is available, albeit it would have to be exercised in conjunction with the employer. Next slide, please. Relevant matters. So again, most, if not all on the call, will probably appreciate that clause 420.1 relevant matters is the SPCC regime for granting monetary relief. So loss and expense can be sought by the contractor for those matters identified at clause 4.21. But as with the position on time, it is pretty slim pickings. So you're looking at, in our view, probably 4.21.1, which is again project change. So if, as the consequence of an instructed change, you are suffering problems sourcing or paying more for material, then that may be something which the loss and expense provisions will engage with. And just be aware that, as with time as a general point, if a project change has pushed you into this period, and it's that project change, which may be an entirely unrelated one, but that's pushed the project into this later period where price increases are now being felt pretty sharply, then again, there may be good grounds to recover loss and expense in connection with that. Next slide, please. SPCC does contain fluctuation options, and the theory would be that those are the way in which the contract is intended to adapt to fluctuating prices for both labour and materials. I suppose first point to note is that option A is the option which is intended to apply by default unless deselected. But option A is, it's pretty ungenerous when viewed against the backdrop of the sort of competing challenges which are facing the sector at the moment. So option A is really more concerned with regulating any changes in levies and contributions and taxes. So it wouldn't, for example, respond to the fact that timber, cement, steel is far more expensive at the moment. For that, you would be looking for option B to be selected. Now, neither option B or C, and C is effectively pre-agreeing a formula adjustment for certain aspects of the work. Both B and C are no longer pre-printed in the forms, but you can find them on the SPCC website. And my colleague, Juliette Haldane, is going to cover option B in what she speaks about after me. It's worth flagging that these provisions don't operate, so even if selected, and most, if not all, on the call will appreciate, I suspect, that they have rather fallen out of vogue in recent years, but perhaps this recent spike in material increases and so on could be a catalyst for bringing them back. But at the moment, they would not apply beyond the completion date, even if selected. So, naturally enough, if the contractor is prolonged beyond the completion date, then they wouldn't get recovery thereafter. Next slide, please. Some other considerations just to finish on in connection with SPCC, and whilst these are viewed through the prism of SPCC, they'd apply equally really to what David has already described in connection with NEC. And the first of those is really that whilst it's possible to do a contractual analysis at the moment to try and identify which particular party holds the pricing risk, the reality is that if particular goods or material is just extremely difficult to source, it soon becomes a project risk, really. And for that reason, parties ought to be encouraged to try and work together to try and avoid costly disputes in connection with this. We do think there's going to be far greater consideration given to amending design or substituting materials by agreement, again, to try and avoid long lead-in periods and costly disputes in connection with delays in LDs. And do bear in mind that a lot of what certainly I've described this morning in connection with the standard release that could be available on the standard form could well be affected by bespoke drafting in connection with COVID and Brexit. A lot of live projects at the moment, certainly those that are off the ground post-March 2020, have bespoke drafting in them which already seek to regulate the effect of both COVID and Brexit. And whilst I'm not necessarily suggesting those are the only causes of the price increases at the moment, because I think what David touched on is that there's perhaps a cocktail of reasons which industry is looking at and reflecting on. They may well be relied upon to try and disallow what otherwise might be a route to relief. And all of what was said here would similarly apply really as between main contractor and subcontractor. So contractors will also have to carefully consider their position down the line and to see to what extent they can effectively absorb or may have to absorb cost increases, not just how much they can take up the line. And I suppose final thought for me just before passing over is, as we understand it, the Scottish Government have been looking at this of late, and there is the prospect of some sort of policy note coming out from Scottish Government in connection with material price increases. We understand it could be imminent, but we've not seen it, so there's a limit to what we can say about it, and probably far less to be gained from speculating. But certainly, past experience in connection with the COVID release and the policy notes that were issued by Scottish Government last year would suggest to us that that note, if it does emerge, is probably going to be far more focused upon public sector work and encouraging cooperation as between public sector clients and contractors in connection with these issues. But the extent to which it will gain traction in the private sector is probably a bit of an open question. But with that, I will pass over to my colleague, Juliet Haldane.
Thank you very much, Chris. Good morning, everyone. Well, we've heard today from David and Chris about how the unamended NEC and the SPCC deal with material shortages and delays. And I want to look now at what positions we're seeing contractors and clients taking in contracts which are being entered into now. And that's maybe by amending the standard forms or using existing provisions. Of course, a contractor could just include an allowance for late or short materials and price in their pricing programme, but to do so, of course, is going to run a risk of the bid not being competitive. So what we are starting to see contractors seeking to amend new contracts to provide reliefs for the consequences of being unable to source materials and the consequent price increases. I'm going to turn first to the NEC suite of contracts, and in particular, the engineering and construction contract. Now, we all know this is a collaborative contract, and as such, really any project manager on a contract should be aware of shortages and their impact on works and be given an opportunity to proactively manage the situation via an instruction if that is necessary. So as David said, the contractor would be expected in an existing contract to give an early warning under clause 16 of the contract of the shortage. And then if the decision is made at a risk reduction meeting that the works information or scope should be changed to mitigate the effect of the shortage, the project manager should be issuing that change. But as David said, there's no guarantee that that instruction will ever be given. And for example, if a client had requested the building with a steel frame, there's really no alternative to that. And if there's a shortage of steel, it's highly unlikely that the project manager is ever going to issue an instruction with a wholesale amendment to something quite so fundamental. In reality, for contracts entered into now, material shortages should be noted in the contract data from the very start as a matter to be included within the early warning or risk register, so that all parties are aware of the potential issue now, and the early warning process can be used to assist with management of the shortage and, if necessary, a mechanism for agreeing alterations to the scope. So I suppose first tip, when entering into a new NEC contract now, make sure that within the contract data, shortage of materials is mentioned as one of the matters that should be included within the early warning register. David also dealt with the impossibility clause, which in NEC 4 is clause 17, and in NEC 4 it's clause 18. And that provides that the works information or scope, where it contains an impossible requirement, the contractor has to notify the project manager, and the project manager issues an instruction to change the works information and scope. I suppose the question is, does the material or labour shortage amount to an impossibility? If you look up a definition of what that means, it means something that cannot happen or cannot be achieved. And I would say that a material shortage doesn't necessarily mean that the goods can't be sourced at all. What parties could do is to introduce a Z clause, which extends the meaning of possibility to cover an inability to source a specified material by a particular date. And that would then give the project manager the option of changing the works information or scope to preserve the programme, and give the contractor an opportunity to seek additional time or money. Again, though, there's going to be no guarantee that an instruction would be given, or that a compensation event would be given, or indeed that there would be any change to the prices or a completion date. Clause 19 deals with prevention, which this clause, as David pointed out, it does assume that the issue was not known about at the contract date. And I agree with him that for contracts entered into now, material shortages are too well known, and it would be very unreasonable for a contractor just to keep quiet about it in his submission. So I would put forward that the prevention principle and the corresponding compensation event are very unlikely to be any assistance to parties entering into contracts right now. So moving on to the next slide and to compensation events. As David said, I think it's quite unlikely that you're going to manage to shoehorn material shortages into any of the existing compensation events, unless there is a sort of positive instruction in relation to it from the project manager. What we're seeing is parties looking to try and agree additional compensation events. So in NEC 3, that would be done via Z clause, and in NEC 4, it's included as an additional compensation event in the contract data. And it's a clause which specifically deals with the issue of material shortages. The NEC programming regime can be used to define the event. For example, you could say a material which is not obtainable by the date for delivery stated in the approved programme, that thus reduces the scope of the compensation event. And also parties can look to whether the event would give time only, or whether it would entitle the contractor to time and a change to the prices. It would very much depend upon the client's appetite for sharing that particular risk. I think what that does is gives parties the opportunity to really look and see what are the materials that are causing a problem and how are they willing to actually share that risk in a collaborative manner. I think it's also worth looking at is where the shortages are likely to impact on pricing. And David talked about X1, which is one of the secondary options that can be chosen. And it gives the contractor an inflationary increase on prices. As David said, on the fixed price contracts, it's an unamended contract, that risk would sit with the contractor of price increases, whereas under the target cost contracts, the risks initially sits with the client, but then is sort of shared out via the contractor's share. What X1 does is it assumes that the contractor will carry the risk of inflation on a certain portion of the price, but that the client will take the risk of inflationary price increases in relation to specific elements of the works. And here you could include things like steel and concrete and all these things that we know are in shortage at the moment. The calculations made at each assessment date and publishes price indices. And when assessing compensation events at the end of the day, the change to the prices is assessed in base terms. And when the assessment of the amount is due, the price for work done to date is adjusted for inflation. We have in the past seen that employers being very reluctant to use X1, other than for contracts with a very long duration. But I think in this current climate where shortages of materials are well known, and thus fluctuations on prices are very, very likely, they may be more willing to agree that X1 applies in limited circumstances. So certainly something for both parties to consider and take forward. Moving on to the next slide, I want to now have a look at SPCC and JCT. I've set out on this slide here the provisions of clause 2.2.1, which Chris referred to. So where a contractor is unable to source, for example, concrete specified in the contract, and the employer is unable to agree to a substitute, the contractor is going to be in breach of contract. We've got these words so far as procurable appearing, but I don't think that's going to assist the contractor where goods and materials, they may remain available. It's just simply that there's a real problem getting them in. So what we're seeing is that parties might be agreeing to soften the effect of this clause, such that the consent in the last sentence is qualified, such that the consent is not to be unreasonably withheld or delayed. Although I would argue this isn't going to be very much assistance if there's no viable substitute available. Or the clause has been qualified to refer to only specified materials and goods being used, provided that they are timelessly procurable. So in other words, you'd be looking for the contractor to actually say when he was expecting to procure these products, and if the products were not procurable within that time, then there may be scope for the contractor changing what has been specified. Moving on to my next slide. As we've seen, the existing relevant events and relevant matters under SPCC do not provide a particularly clear remedy to the contractor in circumstances where materials and goods are unavailable or subject to late or disrupted delay. As with NEC, for new contracts, parties might consider bespoke relevant events or relevant matters which deal specifically with material shortages. I put a couple of examples onto the slide. The standard relevant events and relevant matters are drafted quite widely, I would say, but I can understand that most employers would be reluctant to agree a very general materials shortages clause. So I would suggest that any new relevant event or relevant matters are drafted with specific reference to the materials which the contractor is anticipating will be an issue. And it could even refer to expected dates of delivery from which to measure the effects of the delay. That way, both parties are aware exactly in what circumstances additional time and/or loss and expense might be awarded. It's not some wide sweeping entitlement. Moving on to the next slide. Chris touched briefly upon the fluctuation provisions. They have been very little used historically, which is, I think, the reason why both SPCC and JCT now only include option A in their contract, with the other two available online. Of relevance here would be option A, which allows for labour and materials cost and tax fluctuations, Where there's any changes in any wages or other emoluments after the base date, then the contract's sum is adjusted to reflect the increase or the decrease. It's assumed for the purposes of this option that materials have been calculated by reference to market prices, and if these rise or fall after the base date, then the net amount is paid to the contractor. I think what's important to note is that unless this clause is amended, the fluctuation option B applies to all labour and materials cost for the works. Now that may not suit everyone, of course. An alternative which is set out in the contract is for parties to include their own bespoke fluctuation provisions. Now, this could be quite a good compromise for parties, and it would allow for fluctuation in the price of only certain goods and materials. A mechanism could be stated for agreeing the increase. You could use your own indices or your own calculations. Other examples we've seen are parties agreeing a buffer above or below which only the recalculation is affected. So, for example, if the price rises by 2% or more, the contractor will get paid more. But if it falls by 2% or more, then only then will there be a reduction in the contract sum. So again, it's something I think parties can be creative by looking at using fluctuations, but perhaps introducing their own bespoke provisions to suit their contract and their project. We're also aware that reliance has been placed on the provisional sums provisions within the SBCC and JCT in order to deal with some price increases. This is where the items in short supply are stated as provisional sums and subject to instruction by the employer. And that would also be a relevant event and a relevant matter. But I think parties should be aware that in order for a relevant event or relevant matter to happen, that provisional sum must have been stated in the employer's requirements. So it's essential that, if you like, provisional sums are not squirreled away into any other part of the contract if parties want to rely on that provision. Jane's going to discuss a mechanism in a minute which she's seen, which requires an instruction to expend certain sums, but with much closer employer scrutiny than perhaps the provisional sums items might allow for. I've talked mainly about material shortages. We are aware of labour shortages. More specifically, a lot of this has come as a result of Brexit rather than COVID or any of the other matters. Generally, this is a contractor risk. Again, worth discussions with your employer when entering into a new contract about whether there's a willingness to share risk, again, by the addition of bespoke, perhaps compensation events, relevant matters, or indeed price fluctuation options. I'm now going to hand over to Jane, and she's going to look at some of the other measures being taken.
Thank you, Juliet. Good morning, everyone. So as Juliet said, I'm going to look at some of the bespoke contractual measures that we've been providing and drafting in projects to really try and assist to maintain programme and to keep track on costs of projects as a result of primarily material shortages faced. And one such measure is putting in place off-site materials agreements, and we've drafted many of these in recent weeks and recent months. And at the moment, as has been mentioned, there is great pressure to secure pricing from materials upfront and place orders for these, and competition is really fierce. It may be desirable for the employer to pay for such materials, even though they remain off-site for a while. So that may be to secure pricing upfront for these materials at the start of the contract, to improve cash flow, or even perhaps to avoid any taxes, etc., that could be later imposed. And if payment has been made for these off-site materials without proper contractual protections in place for the party who's paid, problems can arise if the supplier or contractor later becomes insolvent and the items haven't been delivered to site and, importantly, incorporated into the works. So in Scotland, under a contract for the provision of goods and services, so like a construction contract, like a build contract, ownership of the goods will typically pass from the buyer to the seller when the goods are delivered to the buyer and incorporated into the works and affixed to the structure. Under a contract for the provision of goods only, ownership of the goods will pass from the buyer to the seller when the parties intend it to. So in other words, when it's expressly set out in the contract for title to transfer. And in the context of construction, the solution really is to ensure the employer has title to materials prior to delivery, and that's by separating the provision of goods from the provision of services by entering into a separate off-site materials agreement with the contractor and perhaps also the supplier of the goods. And that will set out when ownership of the materials will pass to the employer. So the SPCC recognises all of this as an option and refers to such an agreement being put in place if agreed between the parties, and I think Chris referenced that earlier in the relevant clause number. Now, it's worth noting the position on all this is different in England. The JCT has a retention of title clause, and that deals with off-site materials. It provides that for payment for materials stored off-site and title to pass, provided that certain conditions are met. So that's all wrapped into the build contract. Now, vesting agreements are the equivalent of off-site materials agreements in England. They are still often, very often put in place for a real belt and braces approach, but the JCT does already contain some provision around it. So there's a style SPCC off-site materials agreement which can be used, but at Brodie's we tend to draft bespoke forms with enhanced provisions, and they set out details of where exactly materials will be stored, how the materials are to be marked, who will have inspection rights, when they can inspect, and who's responsible, importantly, for insurance of the materials off-site and then if they are in transit. So most frequently these agreements are tripartite and can be made between the employer, the contractor and the supplier. But recently I have seen that we've drafted some of these agreements to cut out the middleman, if you like, and have payment made from the employer to a supplier directly, carving out the sum for the materials from the contract sum in the build contract with the contractor. And there are various ways to document all of this, but the key point really to take away is that if significant amounts are paid upfront for off-site materials, one of these agreements needs to be put in place for title security for the employer. Worth noting too that these agreements are very palatable to banks. The banks are just really keen to see that if money has been outlaid for materials upfront, there is some sort of security in relation to these. So moving on to the next slide and next pattern. So we have seen a rise in the use of the procurement route of two-stage tendering. Now, I think that is mainly as a reaction to the current issues faced by the industry, including material shortages and in some ways abundance of new work as well. So for those in the audience who are unaware of what two-stage tendering is, it's typically used for design and build projects and involves engaging a contractor at a much earlier stage of a project. So under stage 1, the employer will tender the project on the basis of an incomplete design, price and programme prepared by the employer's professional team. The successful contractor is then often engaged under a pre-construction service agreement, I'll call it a PCSA, to provide certain services. Now, there is an industry standard form PCSA, but again, we tend to draft our own bespoke styles, usually because they are more robust for employers, and we will typically draft them for developers. At stage 2, the relationship between the employer and the contractor is governed by the PCSA, under which the contractor will usually assist in the design process and advise on a wide range of matters, including buildability, programming, construction work, construction risk, work packages, interface issues and specialist contractors. Now, this is all with a view to working up a fixed or a target cost. And the second stage usually ends with the contractor being engaged under the build contract. So we think this approach is favoured at the moment for a few reasons. Firstly, it allows the contractor a little time to select and finalise pricing with subcontractors and suppliers. And in certain packages, this is required as a result of extreme demand at the moment. Secondly, with an eagerness to attract quality bids from contractors at the moment, employers are listening to the messaging that contractors are not keen to bid single stage design and build at the moment, purely because it's perceived as too risky given the fluctuating marketplace. So as an employer, to ensure a quality contractor bidder list, perhaps consider using a two-stage approach. And as a contractor who may work with trusted clients, perhaps encourage them to adopt this approach. I just wanted to mention in this slide that we are seeing an increased use of option X23 in NEC contracts. So that's an option selected for use with NEC contracts where works are split into the 2 stages. So the works information will set out what happens in each stage, but essentially stage 1 is where the contractor typically leads the development of the design or is consulted in the development of that design, which is carried out by the employer and its consultants. Stage 2 is where the detailed design is constructed as per the ECC. So X23 combines these stages into one contract with a notice to be given by the employer to proceed to stage 2. And although X23 is designed for use with options C or E of the ECC, we have been asked recently by a few clients to draft to amend to make it fit with the option E, which is fixed price, which is relatively challenging, but that's probably a session in itself. Moving on to provisional works package drafting. Now, Juliet referred to this, and I thought it'd be useful to highlight some drafting around this specific mechanism that we've introduced into contracts to really deal with the fact that either A, certain packages just can't be priced at tender stage, or B, prices given at tender stage are at huge risk of fluctuating before the package is placed by the contractor. Now, some of this drafting is bespoke and some actually originates from the JCT prime cost contract. And for those of you who may not have come across a prime cost contract, they're not really frequently used. The contract provides for the contractor being reimbursed the costs it incurs in carrying out the works, so labour and materials, including those from subcontractors, plus a management fee on top to cover its overhead and profit. So the drafting really operates as follows. Provisional works packages are identified within a schedule which is appended to the contract, so those are the tricky packages to place. There may be options of listed suppliers or subcontractors that have been pre-agreed that the contractor can go out to per provisional works package. Tenders are then issued to the agreed list of tenderers and are returned to the employer's agent or the contract administrator for opening. So you've got an independent consultant acting for the employer checking these. The contractor will be under obligations to ensure optimum value is achieved. So the tender process per package will be conducted on an open book basis. And once considering the tender returns per package, the contractor will make a recommendation of its preferred supplier and subcontractor for the relevant package. And importantly, very key for main contractors, there will be a pre-agreed percentage of profit and overhead on the tenderer's costs to be paid to the contractor, and that's written into the contract. Now, that could even be a varying amount per package set out within the works package schedule. So there could be different percentages applied to different packages. But the key thing is the contractor will be clear that it's ring-fenced its profit and overhead, and it will not really be left hung out to dry for sporadic and fluctuating materials costs, for example. So happy to discuss in detail with anyone how we can help with drafting a mechanism such as this for future contracts. And lastly, so last slide, advanced payment bonds. So more employers are being asked to provide cash up front recently and are requesting advanced payment bonds. So advanced payments are really made to assist with cash flow required to cover initial expenses by the contractor. So that could be materials orders, supplier or service provider. So materials with long lead-in times, for example, fall right within this. And when making such payments, we really need to consider the intentions of the parties and draft accordingly for it. So we will consider points like, is interest to be charged? How does the contract deal with repayment in the event of termination? And other restrictions on how the advance payment is to be used. So advance payment bonds are still few and far between in our experience. They're quite difficult to obtain. Now, what they do is they're given by a third party, and they protect the payments made to the contractor up front. So they're regarded as a substitute cash beneficiary, so employers will generally prescribe an on-demand instrument. And if or to the extent the contractor fails to meet the contractual obligations, the issuer will refund the advance payments made by the employer, or importantly, the unearned element of the advanced payment. So there will, of course, be a cost for obtaining an advance payment bond. That needs to be considered and factored into tender price. And as I said, they're currently quite difficult to secure in the current market, but just wanted to highlight them as an option. So that's our run through looking at current contractual provisions and points to consider for future contracts around material shortages. I'll pass back to Alistair to address any questions that have been raised.
Hello, thanks very much, for everybody running through that. Just on that last point on the advance payment, probably see increasingly more of that coming through because of the development of modular construction as well, the requirement to pay up front for that. So while I appreciate the market is probably reluctant to put in place these bonds just now, I think it is just a reality that we will have to see more of them, and the market will have to respond to that in a different way if there's to be a drive towards more modular use. David, I know that there was a couple of questions that come through and you were wanting to come back on a couple of the points that come out.
Yes, we've got a question in relation to NEC, saying are any of the clauses I mentioned relevant if there is only a delay, but it doesn't result in any changes being instructed? And that is a good question. The problem is when we do a session like this and analyse the clauses is we're listing all the clauses that could potentially have any relevance, but there's absolutely no doubt that when it comes to you analysing your contract and what's happened, you need to look at the particular facts of each individual circumstance and what is causing that particular material issue. And if it is the case that there's simply delay, so let's say it's, you know, it's a product and it's just going to take a month longer than you require it by, but there's not any change, then what are your options, and how are any of the clauses I've mentioned of relevance? The answer to that is potentially yes. You can still have an early warning meeting if it's going to impact on the programme. If, however, the decision at that early warning meeting is, you know, you won't do anything bar wait on the materials and try and take other mitigation measures, then that clause isn't going to help you particularly. But if the result of the materials being delayed is you're likely not to hit the completion date in the accepted programme, then the prevention clause, clause 19 and 60.119, the compensation event under that clause for prevention, might well assist you in those circumstances, depending on when you entered into the contract. Because as I mentioned earlier, that clause is only going to help you if the issue is one that the contractor shouldn't reasonably have allowed for. So that's probably your best option where there is simply a delay. Again, if it's going to take you past the completion date, you might also try and use the impossibility or the commercial impossibility argument that I mentioned in relation to clause 18. I think with delays generally, the longer the delay goes on, the more likely you're going to get those sorts of arguments off the ground. But
I think just on that impossibility point as well, David, thinking about it, if you've got employers' requirements that specify a particular supplier, for instance, and then you go to that supplier and they just say, we've closed our books for the time being, that'd be an interesting issue in how you would resolve that. Because I think there was an instance of, was it not one of the steel companies had said it was taking no orders for a while?
Yeah, I think that's right. And that is the difficulty we're facing in this area, is the variety of different reasons causing things, the time people put contracts in place and the actual impact of the delay that's being suffered, it causes problems. I guess as a final point, because we're just about to run out of time, I mean, the one thing on all of this is what we are seeing is parties to contracts trying to work together and get them resolved, and that's undoubtedly the most sensible way to deal with these issues, is the parties getting together and trying to work together to resolve it. So we have seen instances of main contractors working with suppliers when suppliers or subs are bound into prices, but coming back to say the consequence of price increases is they are going to make a significant loss. We have seen a lot of instances of contractors working with them to overcome that, because it's not really in contractors' interests to either have suppliers going under because they've signed up to a contract that's now too onerous, or alternatively having to terminate subcontracts and then go and get another subcontractor supplier, because you're going to end up paying the current price anyway. So I think the advice to anyone on these sorts of issues is try and resolve them if you can. It's going to be the quickest and the most efficient way of getting the jobs finished.
Okay, I think on that note, we've just about hit bang on an hour. My thanks to the presenters who have stuck to their timetable admirably. Thanks for everybody for attending. If there's queries that come through to us, we will come back and respond to you. And obviously, if there's anything else you'd like to pick up with any of us, feel free to do so. Just the usual way. So thank you very much.
Thank you, everyone. Thanks.
Thank you.